All right, Mr. Hudson, we ready?
Yes, sir.
All right. The YouTube feed is running. I will turn my video back on. There we go. And we should be ready to start. This is 17 SC 156244, State versus Dewan Cannon. Mr. Cannon is here in court with his lawyer, Mr. Hudson. Ms. Convery is here for the state. Mr. Hudson, is my understanding that Mr. Cannon is prepared to enter a plea in the case. Is that correct?
That's correct, Your Honor.
Mr. Hudson, we can have you and Mr. Cannon up at the podium if you'd like, or you two can stay at the table. If you stay at the table, we'll probably need to move the piece of plexiglass because Ms. Rivers, the court reporter, is going to need to hear Mr. Cannon, and that microphone is effectively blocked by the plexiglass. So I'll let you two decide, podium or just move the plexiglass. Great. Why don't you two come to the podium? Ms. Convery, are you ready?
I am.
Mr. Cannon, in a moment, Ms. Convery is going to put you under oath and ask you a bunch of questions about your rights and some of the situations in this case. If she says anything or asks you something you don't understand or is different from what you and Mr. Hudson thought was going to happen, will you let me know?
Yes,
You got it.
Yes,
you got to answer out loud to any question that's asked because the court reporter can see you, but she needs to hear you because she's taking down words and not movement. Great. Well, then let's get started.
Sir, if you would please raise your right hand for me. Best that you can. Do you swear or affirm that the testimony you're about to give in the matter pending before this court will be the truth, the whole truth, and nothing but the truth, so help you God?
Yeah, ma'am.
Thank you very much. You can lower your hand for me. Please state your true, correct legal name for the record.
Juan Lamont Cannon,
Okay. How old are you, sir?
19,
How far did you go in school?
9th grade.
Are you able to read, write, and understand the English language?
Yeah, ma'am.
At this time, sir, are you taking or under the influence of any alcohol, drugs, or prescription medications?
No, ma'am.
Is there a prescription medication that you typically receive that you have not received today?
No, ma'am.
Do you understand, sir, that you're charged in indictment number 17 SC 156244 with the following counts? Count 1, a participation in criminal street gang activity. Counts 2, 3, 4, and 5 are felony murder counts. Count 7, aggravated assault with a deadly weapon, as well as counts 8 and 9, also aggravated assault with a deadly weapon. Count 10, criminal damage to property in the first degree. And count 11, possession of a firearm during the commission of a felony. Do you understand that, sir?
Yeah, ma'am.
Do you understand also, Mr. Cannon, that you have the right to either plead guilty or not guilty to the charges that I just read to you, or you may remain silent and receive a jury trial?
Yeah, ma'am.
Have you been able to go over the plea of guilty form and the waiver of the rights information and form with your attorney?
Yeah, ma'am.
Have you had enough time to speak with your attorney about all of the facts and circumstances of this case, including any and all possible defenses to the charges?
Yeah, ma'am.
Do you need any more time to discuss this case with your attorney?
No, ma'am.
And are you satisfied with his services?
Yeah, ma'am.
Counsel, do you have a formal reading of the indictment?
We'll wait.
And do you have any and all defects therein?
We'll wait.
The state is aware that Mr. Cannon has been arrested on these charges, was subsequently released and then rebooked actually on these charges. The state is unaware of any outstanding warrants as it pertains to this case. Are you or your attorney aware of any outstanding charges or warrants?
You're not.
Sir, has your attorney advised you of the minimum and maximum for each of those charges that I just read to you?
Yeah, ma'am.
All right, do you also understand, for the record, I'm going to go over the same. Count 1, participation in criminal street gang activity has a minimum of 5 years and a maximum of 20 years. Counts 2, 3, 4, and 5 are felony murder, which carry a life sentence. But understand that the state will be recommending that the court vacate counts 3, 4, and 5 as an operation of law. Count 6, armed robbery, has a minimum of 10 years and a maximum of 20 or life. Count 7, 8, and 9, which are all aggravated assaults, have a minimum of 1 year and a maximum of 20 years. Count 10, which is criminal damage to property in the first degree, has a minimum of 1 year and a maximum of 10 years. And count 11, possession of a firearm during the commission of a felony, has a 5-year sentence to run consecutive to the court sentence on the other counts. Do you understand all those?
Yeah, ma'am.
You understand that you're pleading guilty to felony murder in this case. You're pleading guilty to a serious violent felony.
Yeah, ma'am.
Do you understand that you will serve the entire prison portion of the sentence imposed for this serious violent felony without the possibility of parole?
Yeah, ma'am.
You also understand that while you would be eligible to be considered for participation in a Department of Corrections administered transitional center or work release program during the final year of your incarceration, you will not be eligible for any other sentence reducing program that's given at the Department of Corrections or the Board of Pardons and Paroles.
Yeah, ma'am.
You also understand that Mr. Cannon, that neither the court, the district attorney's office, or your attorney has anything to do with parole or the Department of Corrections or the Board of Pardons and Paroles, and no one could guarantee you parole.
Yeah, ma'am.
You understand that today's plea is what's called a negotiated plea of guilty, which means that your attorney and I will be making essentially the same recommendation to the court as it pertains to sentencing, but that ultimately it's the court that will decide your sentence within that range that's authorized by law that I just read over to you.
Yeah, ma'am.
Do you understand that this plea may be used to enhance sentencing on other convictions in this jurisdiction as well as other jurisdictions in the future, including the federal courts?
Yeah, ma'am.
Mr. Cannon, do you understand that if you are currently on probation and parole, your probation or parole may be revoked as a result of today's guilty plea?
Yeah, ma'am.
Do you also understand, Mr. Cannon, that if you were placed on probation as a part of today's sentence in any form or duration, you may not violate any criminal laws of any governmental unit or any special conditions of that probation without them being subject to a revocation for the remainder of your sentence?
Yeah, ma'am.
Do you understand that you are not allowed to use or possess a firearm while on probation?
Yeah, ma'am.
Also, Mr. Cannon, do you understand that if you are not a United States citizen, a guilty plea conviction will affect your immigration status? And this is true of the advice of your attorney or anyone else.
Yeah, ma'am.
Do you understand, sir, that there may be other adverse or unfavorable consequences as a result of today's guilty plea conviction? For example, today's guilty plea may affect your right to vote, hold public office, serve on a jury, obtain a passport, or the right to receive, possess, or transport a firearm.
Yeah, ma'am.
You understand, Mr. Cannon, that by pleading guilty to a felony today, if you then use, receive, transport, or possess a firearm, or if you used a firearm in another crime, you would be guilty of a felony and it will carry a sentence of 1 up to 15 years in prison.
Yeah, ma'am.
You understand, Mr. Cannon, that you waive any and all defenses today by entering this guilty plea, including any mental health defenses.
Yeah, ma'am.
You understand that if you chose to go to trial, you would have the right to a trial by jury, which means the right to see, hear, and confront the witnesses called to testify against you, and the right to testify or to remain silent and not incriminate yourself.
Yeah, ma'am.
Mr. Cannon, do you understand that by pleading guilty today, you are giving up or waiving the following rights? The right to a trial by jury, the right to remain silent and not incriminate yourself, the right to confront the witnesses called to testify against you, the right to the assistance of counsel hired by you, or to court-appointed counsel if you could not afford an attorney, the right to the presumption of innocence, the right to testify on your own behalf and present other evidence, the right to subpoena witnesses and compel the production of evidence, the right to have the charges against you proved by the state beyond a reasonable doubt, and the right to appeal if convicted of these charges after a trial.
Yeah, ma'am.
Do you understand that, has anyone forced, threatened, or promised you anything to get you to enter this guilty plea today?
No, ma'am.
Is it your decision to waive the rights that I just outlined to you and enter this guilty plea because you are in fact guilty?
That's for the we did it also wrong. This ain't wrong. Ms. Convery, did you go through every count? Is that possible?
Oh,
Just
I'm
for
going to do the
clarification.
plea, but so let me ask it in a different way. Is it your decision to waive the rights I outlined and enter a guilty plea because you are in fact guilty as it pertains to counts 2 through 11 of the indictment?
That's everything except the gang charge.
Yeah, ma'am.
Right, and is it my understanding that you intend to offer to this court an Alford plea as it pertains to count 1, participation in criminal street gang activity?
Do you know what an Alford plea is? Because I'm happy to explain that.
Yeah, I know what it is, but can you explain to me again?
Sure. So there was a U.S. Supreme Court case called North Carolina versus Alford. And in that case, the Supreme Court said it's okay for a judge to accept a plea from a defendant who says, I didn't do everything the state says, but I think it's in my best interest to take this deal. Didn't go down the way they said, but I don't want to go to trial because that could be a whole lot worse. That's an Alford plea. And normally the judge would push back and say, hey, Mr. Cannon, if you didn't do it, go to trial and let the jury decide. But sometimes, especially if you're admitting to some of the other stuff, I shot the guy or whatever the facts are, and I haven't heard them yet, or I was there and I was part of the group that shot the guy or robbed the guy. It doesn't make a lot of sense to fight over just one charge. And so you're in an Alford plea. You're telling me and the whole wide world, I wasn't mixed up in it that way, but these other things, yep, I admit to that. Sometimes Alford pleas to the whole case. You're in a stolen car, and you know what? I don't want to go to trial, but I didn't know it was stolen. The guy told me it was a good ride. I drove it, and I didn't know, but I don't want to go to trial on it. This is different because you're pleading guilty to some of the counts, but what I'm hearing you say is to count 1, it's about the street gang stuff. You're saying it's not what the state has to say, but I just soon enter a guilty plea and move forward. Does that describe your situation?
Yes, sir.
Okay, then I will, later on, I'll let you know if I'm going to accept the whole plea, but you can go forward with an Alford plea as to count 1 and then a guilty plea as to all the other counts. It's important that you understand it still shows up as a conviction, so it's not going to change your sentence because you said Alford plea. It's not going to list any differently, but it's going to be in the record that it was an Alford plea as to count 1. You understand that?
Yes, sir.
Okay. Ms. Convery?
All right, then, sir, how do you plead in 17 SC 156244 to count 1, which is participation in criminal street gang activity, guilty or not guilty?
Not guilty.
For count 1, you're entering a plea of.
So it's important. We'll walk through this. 2 through 11. Are you going to do each count one at a time?
Only because there's this.
Okay.
Section, yeah.
So count 1, which is the participation in criminal street gang activity. You've got 3 choices. Guilty plea, not guilty plea, which means next Monday we'll get you a jury trial on that, or Alford plea, where you're saying, like I just described, I didn't do that, but I don't want to fight it. And so I'm entering a plea on that one. So Ms. Convery's question to you is just this to count 1, the street gang piece. Are you pleading guilty? You pleading not guilty, I want a trial, or are you entering your plea under Alford?
Alford.
Okay.
All right, and then, sir, as it pertains to counts 2 through 5, which are the felony murder counts, how do you plead to those counts, sir? Guilty or not guilty?
Yes.
Count 6 is armed robbery. How do you plead to that count, sir? Guilty or not guilty?
Yes.
Count 7, 8, and 9 are aggravated assault with a deadly weapon. How do you plead? Guilty or not guilty?
Yes.
Count 10, criminal damage to property in the 1st degree. Guilty or not guilty?
Yes.
And count 11, possession of a firearm during the commission of a felony. Guilty or not guilty?
Yes.
Does the court, I know we're in different times. Normally I would tender to the court a signed indictment.
So I've got the indictment here, and I can do that now. I usually do it at the end, but let me ask Mr. Hudson first, in case Ms. Convery didn't. This is a copy of the indictment. Do you waive any issues that might arise from proceeding with a copy of the indictment in this case, Mr. Hudson?
No, Your Honor.
You do waive?
I do waive.
Okay, great. Mr. Cannon, I know you signed one document today, and we'll verify your signature on that. Normally, we'd have the original indictment. You'd sign that as well, but we try to pass fewer pieces of paper around during the pandemic. Do you authorize me to sign your name on the indictment?
Yes, sir.
Okay. Mr. Hudson, can I sign your name on the indictment?
Yes, Your Honor.
And Ms. Convery?
Yes, sir.
Okay. And just so there's no confusion, all your signature means is that you're entering your guilty plea. We put that on the indictment as well. So I'll put your signatures, all three of you, and then I'll make clear on there that I put the signatures on there, but it was with your permission, and we're making a record of that now, so there are no surprises. So if you'd verify the signatures on the guilty plea sheet, we should be good to go.
And I'm going to send it to the court at this time to sign a waiver of our form.
Thank you.
For the plea that we just outlined with the court, the guilty plea and then the Alfred on count 1, is that plea freely and voluntarily given with full knowledge of the charges against you?
Yeah, ma'am.
Do you understand that you may only have a limited right to appeal today's guilty plea conviction?
Yeah, ma'am.
And do you also understand, Mr. Cannon, that you'll have 4 years from today's date to file what's called a habeas petition, which would challenge the voluntariness of today's plea?
Yeah, ma'am.
And would Your Honor like me to give a factual basis?
Please.
Should this matter have proceeded to trial, the state would have been prepared to prove beyond a reasonable doubt that on July 2nd, 2017, at approximately 10:40 p.m. that night in the Walmart parking lot located at 1105 Research Center Drive in Atlanta, Fulton County, Mr. Cannon, Mr. Andre Griffin, Mr. DeMonta Williams, and Mr. Trevante Daniel arrived at that location in an attempt to facilitate some sort of a gun deal with Mr. Jeremy Breaux, and that's B-R-E-A-U-X, and Mr. Billy Parson. That gun transaction actually unfolded into an armed robbery that Mr. Cannon initiated when he came up to the vehicle, and as a result of that, Mr. Daniel was killed in an exchange of gunfire. The group that arrived to the location included Mr. Cannon, Mr. Andre Griffin, Mr. DeMonta Williams, and Mr. Daniel all in one vehicle, with Mr. Jeremy Breaux and Mr. Billy Parson arriving in the other vehicle. Mr. Breaux parked his vehicle adjacent to the vehicle of the other group, Mr. Cannon and the co-defendants. And Mr. Breaux was subsequently interviewed and was able to describe the other vehicle as a light-colored sedan. Mr. Breaux explained to, eventually, Detective Terrence Jackson from the Fulton County Police Department that a light-skinned male with dreadlocks, tattoos, and a missing eye that was later subsequently identified as Mr. Andre Griffin exited that light-colored sedan, entered the rear seat of his vehicle, and asked to view the firearm that they were there to buy. That firearm was a black Taurus revolver. Mr. Breaux and Mr. Parsons handed the revolver to the back seat. Mr. Griffin sort of reviewed the handgun, made some remarks that, hey, this is old, supposed to be a new weapon, and asked permission to take the weapon out of the car and move back to his friend's vehicle, which would have been where Mr. Daniel, Mr. Cannon, and Mr. Williams were.
You said Mr. Griffin was distinctive in part because he was missing an eye?
That's correct.
As in he had an eye patch, or there just was no eye in one place? Okay.
As a result of a previous shooting, I believe, actually.
Okay.
So permission was denied to take the weapon out of the vehicle. Instead, they offered to have whoever from the other vehicle wanted to check out the gun come to their car. So Mr. Griffin accepted that offer, gets out of the vehicle of the sellers, Mr. Breaux and Mr. Parsons, goes back to the vehicle he arrived in, and later brings back Mr. Daniel to the vehicle. So now we have Mr. Griffin and Mr. Daniel in the back seat, Mr. Breaux in the driver's seat, and in the front passenger seat, Mr. Parson. They're still reviewing this revolver. They asked actually for some live rounds, ammunition to make sure the weapon fires. While this exchange is happening, Mr. Cannon gets out of that light-colored sedan and approaches the driver's side of the seller vehicle. When he approaches the driver's side of the vehicle, he brandishes a weapon, points it to the face of Mr. Breaux, tells him, you know what it is, give it up. Mr. Breaux and Mr. Parson, very surprised by this, to which Mr. Parson exits the vehicle, sort of takes off, gets out of the front seat of the car. Mr. Griffin and Mr. Daniel attempt to do the same in short order. Before that happens, sort of as an instantaneous reaction, Mr. Breaux, that driver, will go on to tell detectives from the Fulton County Police Department that Mr. Griffin, who was actually with Mr. Cannon, remarks, "Kodak, you trippin'." Kodak is an alias for Mr. Cannon, nickname that he goes by. So as a result of everyone being surprised, Mr. Cannon's at the driver's seat of the vehicle with a firearm. All parties sort of flee that seller vehicle and take off. In the immediate flight afterwards, Mr. Parson fires several rounds back in the direction of the attempted robbery scene.
Not with this Taurus revolver. There's another gun.
A 9mm.
Okay.
Right. Both the Taurus revolver and the revolver that Mr. Cannon had on his person and used to actually facilitate the robbery were recovered. It appears that Mr. Cannon fired probably one round. There's one spent casing inside the revolver. Mr. Parson gets off several more. Mr. Cannon actually sustains multiple gunshot wounds as a result of the shooting. Mr. Daniel also...
So we believe Parson hit Cannon.
Right.
Good.
Yeah, multiple times. Mr. Bro also, I believe, based on the sort of totality of the evidence, also fires a couple of times a .40 caliber weapon from inside the vehicle. There are .40 caliber casings found on the scene, as well as in the process vehicle that he fled the scene in. Mr. Daniel sustained one gunshot wound, but unfortunately, as a result of where he sustained the gunshot wound to the back, he eventually succumbed to his injuries there in the parking lot, while Mr. Cannon also laid in the parking lot as a result of his injuries.
Do we know if Mr. Daniel was hit with a .40 caliber or a 9mm through and through?
Correct.
Okay.
As a result of those injuries, they're there in the parking lot. All the other parties were able to flee the scene. Mr. Parson, that's that front seat passenger that fires the primary rounds. He actually sustains a gunshot wound as well to the leg, flees to the closest MARTA bus, gets on the bus and is spotted immediately by citizens and the bus driver. They call the Atlanta Police Department, who facilitates a connection to Fulton County, and they eventually are able to interview Mr. Bro, Mr. Parsons, later down the line, Mr. Cannon, while he is in the hospital, as well as the co-defendants, Mr. Griffin and Mr. DeMonta Williams, who's the last person to be identified. He sort of remains in the buyer vehicle, that light-colored sedan. All of the interviews are consistent with the investigation physically on scene, except for that .40 caliber round being fired at the scene. But essentially, everyone says they're there to buy a gun. That the day before, Mr. Andre Griffin had met up with Mr. Parsons and Mr. Bro at a gas station. They talked about them having a gun that was for sale, and they decided to do the deal the next evening in the Walmart parking lot. All parties consistently described to law enforcement that they were surprised that Mr. Cannon approached the driver's side vehicle with the firearm and attempted to facilitate an armed robbery there at that location. Mr. Cannon was interviewed, admitted to being at the location, but denied, knowing that they were there to get a firearm, but denied any knowledge of the armed robbery. Essentially, he was there and gunfire erupted at the car. The physical scene, to include the vehicle and the parking lot, are also consistent with the other interviews that law enforcement conducted with the involved parties. And initially, Detective Terrence Jackson charges everybody, including Mr. Parson and Mr. Bro, basically felony murder predicated on the firearm transaction, because the firearm that was being sold, that revolver, was in fact stolen out of DeKalb County. Subsequent investigation from our office and a review of the totality of sort of the information and how it applied legally, we decided to charge the case in the way that it currently is before Your Honor. And I've taken all the facts and circumstances into account when I made a recommendation to counsel and when I'm going to make the recommendation to the court as it pertains to sentencing. Just a little bit specifically on the gang count. Mr. Cannon, as a result of investigation in our office in particular, specifically ADA Mike Sprinkle, there was social media reviewed, a lot of social media reviewed for each of the defendants, to include Mr. Cannon. Mr. Cannon has an alias that I've already told the court about. It's Kodak, Kodak. His social media handle on Instagram at the time of the incident was ABG Kodak. ABG is a popular Atlanta criminal street gang known as the Atlanta Blood Gang, which is a subset of a larger national criminal street gang known as Inglewood Family Gangster Bloods, a West Coast-based gang. Mr. Cannon demonstrates that affiliation not only with his alias and name, but the content of the social media account itself. Unfortunately, Mr. Cannon has continued to demonstrate affiliation with this criminal street gang while incarcerated at the Fulton County Jail, has tattoos consistent with his membership as well, and holds out an affiliation with not just this local blood group, but the larger national criminal street gang that is If Gang or Inglewood Family Gangster Bloods. Inglewood Family and the local subset to include ABG are known primarily nationally to commit drug trafficking style crimes, but are also notorious as well for armed robberies, pedestrian robberies, aggravated assaults and shootings to include homicide. At the time of this incident, Mr. Cannon was the youngest one in the group. He was 15 years old. He would have turned 16 later that month in July. Facilitating and really being the initial person to make an armed robbery happen at a gun deal like this would certainly be something from the state's perspective that would increase his reputation and status within that criminal street gang affiliation and group, specifically Inglewood Family Gangster Bloods. He also demonstrates, just for reference, a closeness to the Atlanta hybrid criminal street gang DFW, known as Down for Whatever. He appears to demonstrate a sort of loyalty and association with Charlie and Isaac McDaniel, who were prosecuted around the same time as this incident for a homicide.
These are the Sliders, the McDaniels.
Yes.
Okay.
A review of Mr. Cannon's juvenile history. So this is his first, obviously he was SB 440 at the time of this homicide. He has picked up some additional incidents inside the jail. They appear all to be misdemeanor battery in nature. There is an arson in the 3rd degree as well, all picked up while inside the Wright Street facility. He has a theft by receiving, 2 theft by receivings from 2016, a burglary from 2016, another burglary from 2017, and an aggravated assault from 2018. All those are all juvenile adjudications before this incident actually occurred. I tried to take into account the age of Mr. Cannon, the fact that he sustained some serious injuries and was lucky really to leave that scene with his life. I do not believe, based on my review of the evidence, that his firearm caused the death of Mr. Daniel. However, from the state's perspective, he is the initial sort of kickoff to the series of events that would lead to the taking of a life of Mr. Daniel. So all those things are taken into account, and I am prepared to make a recommendation to the court.
Research Center is where?
I think it's actually an Atlanta address, but it will fall in, if it was today, it would be South Fulton.
Okay.
2017, this would have been Fulton County Police, right? About 6 months after this, they would have done the divide to City of South Fulton.
Okay. And Mr. Williams, as far as you understand, never got out of the car that he and Mr. Cannon and Mr. Griffin and Mr. Daniel showed up in.
That's right. And I'll talk to the court about that later if we're before you in a plea posture on Mr. Williams. But there was some social media posting that happened in the days following this shooting where Mr. Daniel describes we were just trying to get some money.
Mr. Williams describes.
I'm sorry. Yes.
Okay.
Just basically saying RIP to Mr. Daniels and make some comment about trying to get some money. But the state's in a totally different posture as it pertains to Mr. Williams.
And then Mr. Griffin and Mr. Griffin was the first one out of the car, sitting in the back seat.
Right. He's the one who has that relationship.
Sure. And then he's joined eventually by Mr. Daniel.
That's right.
And then everything goes sideways.
Right.
Okay. And I know today we're here on Mr. Cannon, but you believe if and when I learn more about Mr. Griffin and Mr. Williams, there'll be similar connections to ABG and or DFW?
Actually, believe it or not, and this is something I'm sadly seeing all the time, there are similar connections to a criminal street gang organization, but totally different.
Okay.
Mr. Griffin demonstrates an association with the group Gangster Disciples, both in social media and text message content in every way. Someone can be affiliated, tattoos.
Okay.
Mr. Williams is going to demonstrate an association with the criminal street gang YSL, or Young Slime Life. And this is not atypical to see groups that hold allegiance to a different local group working together for a common cause, whether it's to buy a weapon or to facilitate an armed robbery.
Got it. I am ready to hear your recommendation.
All right. As it pertains to count 1, which is that participation in criminal street gang activity count, the state's recommendation is 20 to serve 18. And just so the court knows, in case I give anything incorrectly, my attempt is to make a global recommendation for 25 years to serve 18 years.
Okay.
For count 2, that will be my recommendation, 25 to serve 18. I'm asking to depart under 1710 6.1E. For counts 3, 4, and 5, the state's position is that those would vacate. As an operation of law, there is only one death as a result of this incident. For armed robbery, my recommendation to the court would be 20 to serve 18.
So why wouldn't the armed robbery merge into the felony murder? Because the felony murder that you think should not be vacated, count 2, is that not for the armed robbery? It is. So I was starting to look up on Westlaw, but then needed to plug in with you all. I agree that the other 3 felony murders vacate. You have only one person died. Fortunately, it was limited to 1. So there's only 1 murder conviction. It's a felony murder conviction. But wouldn't the armed robbery merge into the felony murder, count 2, 6 would merge into 2. Then the question becomes, did 7, 8, and 9 also merge, even though the felony murders were vacated? And that was actually the case law I was looking up, is that I'm remembering something that, well, wait a minute, if the felony murder was vacated, then the underlying felony, it can't merge into something that was vacated.
That makes sense to me. I want you to look it up for sure.
Okay.
But that makes sense to me. And I don't have a strong, like I said, my global, I've already talked about, and I've asked Ms. Burlock to make sure that she communicates the vacate thing. Nothing's being, null crossed or dismissed. But,
Sure.
And I certainly don't want to be back before the court because of a merger issue either.
Well, what I'll do, I'll hear you out on this. I'll certainly hear from Mr. Hudson. I'll do the research, and before I sign the final disposition, I think what's going to matter most to Mr. Cannon will be what are the numbers, and I'll make sure that it's structured that way. Question about you'll want to think through the parole piece, because if armed robbery merges into felony murder, I don't know what the parole eligibility would be. It's different. I know with the armed robbery, it's not parole eligible, but I think all the other offenses on here are. So if your aim was to create a non-parole eligible sentence, then it may need to be a different felony murder that you suggest should be the one that is the standalone and that the others are vacated. So I'm not trying to make it more complicated. I just don't know what you all negotiated. I want to make sure that the sentence ends up being a legally valid one. It's not going to be, assuming I go along with a recommendation, it's just a question of how we structure it and what the party's intent was. And if the agreement was that Mr. Cannon would not be eligible for parole, it ought to be structured that way.
Yeah. So that is the state's intention, and that's my understanding. I've deviated on the number because of the things that I mentioned.
Sure, he's not facing a life sentence because he was 15 at the time, right. And it doesn't sound like he fired the shot that killed Mr. J. I mean, it all makes sense. I'm not critical of this. This seems is a real big number for a guy who's 19 years old, but it makes sense given the consequences of what Mr. Cannon started. So I just want to make sure that in the end, when we structure this on the technical side, it supports what was negotiated.
Absolutely.
Okay.
And that is my intention for a net effect of 25 to serve 18 that is not parolable.
Got it. So it would be 18 to serve on all of the non-life sentences. So count 6 through 9. We'll figure out which ones vacate or don't or merge. And then 8 to serve on count 10. And then plus 5 probated on count 11.
I was going to do 5 consecutive suspended.
Suspended. Okay.
Yes.
All right.
Yeah. So, and please let me know if I need to make any additional announcements, but I think the court has a good idea of what we negotiated. As far as special conditions that I'm recommending, I am asking that the court give some pretty specific recommendations on no further gang affiliation. I'm asking that the defendant, of course, not have any further gang affiliation, hopefully not while in custody in the Department of Corrections or afterwards while he's being supervised. I'm asking that he not affiliate with any criminal street gang of any kind or variety, through social media or otherwise, that he had no firearms or replicas of firearms demonstrated on social media or otherwise while on probation, that he had no contact with the co-defendants, which I don't believe that'll be any issue at all. And I don't think there's been continued contact of any variety since this happened, actually. And that's it for special conditions. I do
Okay.
have one, obviously I've got multiple members of the family here.
Sure.
To say, just so that I know the court knows, but I'm newer to the case, but I know that this family has been invested in this process since the very beginning. I met with them when I took on the case, and I know that they've been here for every court date that the court has had. And since this case has been pending, I think the court saw how many people were logged on to the last time
Yes.
we were possibly going to attempt to plea. On behalf of the family, I know Ms. Thurmond, who is Mr. Daniel's mother, has an impact statement she'd like to offer to the court when it's appropriate. But I did want to let you know that the entire family has been sort of plugged into this process and is very invested in the ultimate outcome.
And has been waiting a long time. Okay. Ms. Rolak, I'm going to defer to you to let me know who wants to speak. If whoever it is going to be wants to just come to the edge of council table there, that would be great. Good morning.
Good morning, Liz. I have a written statement for mother, her name is Tanisha Butler. And after,
Before you go any further, let me make sure that Ms. Rivers can hear you, because you're not near a microphone, because there really isn't one for you to be near right there. Ms. Rivers, were you able to hear Ms. Rolak?
That wasn't very clear to me. No, I was not.
Okay. If you don't mind, the microphone at the prosecution table, if you can leave just, pardon me? Great. Okay. All right. Mr. Cannon and Mr. Hudson, if you take a seat, we'll get you back up to the podium when it's time for you all to share with me your thoughts. And Ms. Rolak, why don't you and Mr. Daniel's mother come on up to the microphone there? Great. All right. Let's try that again.
good morning.
Good morning.
Mona Rolak, Deputy Victim Witness Advocate with the Fulton County District Attorney's Office. And I'm here with Tanisha Thurmond Butler. She has a statement. My name is Tanisha Thurmond Butler, THURMOND, Butler, BUTLER, Tanisha, TENISHA. Myself and Gerard Daniel, GEOROD, Daniel, DANIEL, gave birth to a son named Trevante Dion Daniel, TREVEONTE, Dion, DEON, Daniel, DANIEL, on September 12th, 1996. We watched him grow into a loving son, brother, nephew, cousin, and grandchild. Trevante was surrounded by love and laughter, and also full of life by his family. He was the oldest out of 14 kids and a father of 2 little girls, Zariah and Zion. On July 2nd, 2017, we received bad news that we lost a loved one who was just 20 years of age. His life had just begun. He was working with his father and grandfather on different jobs as a subcontractor. This has affected the whole family, and it has changed our life in a big way. As I can say, nobody expected this to happen. Have you ever had that one person in your family that held the family together? In this case, Trevante was that person in our family. Now we are still trying to put the pieces back together. He always had a smile on his face, showing all 32 teeth. And if you knew him, you did not have a choice but to fall in love with him. He was that type of person that was loved by everyone who he came in contact with. Trevante was a person who was big on family, and to him, family came first, no matter the circumstances. As he would say, he wanted all 14 of his siblings to look up to him by stating the fact that each and every one of them told each other to cherish every single moment they shared. with each other, which always brought the family into the light. Till this day, it still hurts to see a loved one gone so soon. By now, people would have thought that we may have evolved, but to tell the truth, our answer is no. We're not able to celebrate his birthday, Christmas, Thanksgiving, or any holidays and/or special occasions together. He will also not be able to see his daughters grow up. Till this day, the defendant's family is allowed to still see him, watch him breathe, smile, or even tell him that they love him. Sadly, we are not able to do the same anymore. Our family can only look at pictures, speak about the memories, and more along with wearing him around our necks. The family will always be numb and will not have nor show any feelings of this tragedy. I pray that this sentencing brings closure to all of us. Sincerely, from the Daniel family.
Thank you, Ms. Thurman Butler, for sharing that.
Thank you.
So you had 14 kids?
No.
No.
His father did. I have two with him. Two, and that's my son and his brother, and I'm raising his two grandbabies.
Got it.
I'm raising his two daughters.
Okay.
Yes.
Well, that was my next question is where are his daughters? And they're with you?
Yes,
Okay, great. Well, thank you for taking care of them.
always.
I'm sorry this process has taken so long. Obviously, the last year has been sort of out of our hands in terms of moving cases along, but this is something that for Mr. Cannon's sake, and in particular for your family's sake, we should have tried to get closure on sooner. Not because it heals, but at least it closes a chapter and you're able to move on. So on behalf of the court system, I apologize that this has dragged on as long as it has. It's not been intentional. It's nothing Mr. Cannon did. It's nothing that the court did intentionally, but you all deserve some answers. And it sounds like today some are being provided. And I hope it helps you move forward a little bit. But as you pointed out, every Christmas, every holiday, there's going to be something missing. And that's tragic.
Yes.
Thank you for being here.
You're welcome. Thank you. Your Honor, may I say something?
To me, you may, yes.
May I turn to address Mr. Cannon?
Nope, but you can say things
Okay.
that I promise he's listening.
I
But
understand,
you and
yes.
I are going to
Yes.
keep the focus.
I want Mr. Cannon to know that let me take a deep breath. I forgive him first and foremost. He have been the person that been the most remorse in this situation. He always gave me eye contact when I came in the courtroom to tell me he's sorry. And out of all of that, I believe him. And I wish him the journey. I don't want to say the journey, but I know he will make peace of this, and I allow him to making this step for us as a piece as well. And I know that God has him in his arms, and he's gonna get through there because I know his loved ones love him as well. But I know he had to make this decision for himself. But I want to tell him that my family, on the behalf of my family, that we forgive him in this tragedy of it all. Thank you.
Thank you. That is very gracious of you to share that. And I think it's healthy too. A sad part of this job is that I meet a lot of moms who lose their sons or their daughters because of something senseless like this. And I'll tell you, the ones who don't let go are the ones who remain unhappy the longest. So that's real healthy. But I think you're also speaking the truth here. Your son's not going to hold his babies anymore. There is light at the end of a long, long tunnel for Mr. Cannon, and he'll get out and he'll be back with family, and hopefully he's grateful for that. But most of all, I appreciate the poise you're showing in sharing what you shared. Thank you.
Thank you. Thank you.
Ms. Rolak, is anyone else from Mr. Daniel's family going to be speaking? Okay, thank you for sharing that. Mr. Hudson, well, before you get up, anything else, Ms. Condrey?
No, Your Honor.
All right, thank you so much. Mr. Hudson, if you and Mr. Cannon could come back to the podium, please. Whatever you'd like to share about Mr. Cannon's situation, I'm happy to listen.
Sure. Thank you, Your Honor. I think first I would like to thank Mr. Daniels, his family, for those words. It has been a while since this case was first initiated, and Mr. Cannon has never, with me at least, shirked from his responsibility in this matter, and he's always been very straightforward with me and relatively pleasant to work with throughout this process. And so I appreciate his diligence as well as also the words from the family judge. I guess as an initial matter, to address the offered plea on count one, just for my position. It was my decision to have Mr. Cannon enter an Alford plea. The state has laid out an affiliation, certainly, but as it relates to this occurrence actually furthering the mission of that particular gang, I feel that the evidence is not there. However, I did not want that one count to derail the entire.
No, I appreciate the thinking, and I always learn something new from both sides when we wade into the supposed gang area. It was interesting to me to learn that Mr. Cannon, Mr. Griffin, and Mr. Williams, insofar as they affiliate or identify with a group, they're three different groups. And so I think that lends some credence to your position that you're taking as to why Mr. Cannon ought not to enter a straight guilty plea to count one. It's not affecting my sense of Mr. Cannon's acceptance of responsibility. This was about the armed robbery going bad and the tragic result. It sounds like we almost lost 2 lives. Mr. Cannon is still here, but if bullets had been slightly different places, there'd be 2 victims. And I don't know, maybe Mr. Parson or maybe Mr. Griffin and Mr. Williams would be looking at real serious sentences. But I appreciate your reasoning as to count one.
Thank you, Judge. Your Honor, also just my 2 cents on merger and sentencing.
Mm-hmm.
I believe that the best sentence would be, obviously, we have our guilty on count 1 with the 20 serve 18. The felony murder that coincides with the gang count, I believe the court should sentence on that. I believe that's count.
That's count 5.
Yes.
You're saying that count 5 should be the felony murder that stays in place?
Exactly.
And then the others. What is your understanding of the impact of vacating a felony murder on the underlying felony? I'll look it up, but here's how I think it works. Let's take a simpler case. Malice murder, felony murder, armed robbery, and an ag assault. The 2 felony murders that are based on the armed robbery and the ag assault. And there's a malice murder. Found guilty of malice murder. Clearly the felony murders have to go away. So they're vacated. Well, the armed robbery and the ag assault are still there. The ag assault would merge into the murder because what killed the person was the firing of the gun, the ag assault. The armed robbery didn't kill anyone. And the armed robbery doesn't disappear because the felony murder was vacated. The armed robbery comes back into the mix, I believe. And so what I think is going to happen here is if I follow your counsel and sentence Mr. Cannon on count 5, that felony murder, count 1 would merge into it, but then the 2 aggravated assaults and the armed robbery, I'd need to impose sentences on. And I would, if I follow everyone's recommendation, would do 20 to serve 18. I think that's how it works. I will confirm by doing some legal research, but I wanted to get input from, because one of you might have come in and said, no, look at State versus Jones. What happens first is the merger of the underlying offense into the felony merger, and then it's vacated. So as the felony murder leaves the scene, so too does its underlying felony. I don't think that's how it works, but I'm not so certain in my answer that I'm going to tell you right now, here's how it'll work. I'll do the research. You'll see the final disposition before it's official. So if you want to make a legal argument that that wasn't the right way to do it, I can take that into consideration. Okay?
Yes, sir. Your Honor, outside of that, I don't believe there's anything other to say other than what's already been said here already. We do have a pretty tragic situation here. Unfortunately, Mr. Daniels has succumbed to his injuries. Mr. Cannon, he was taken to Grady. He stayed there for quite a while. He sustained, I believe it's 8 gunshot wounds. And he is still having slight physical problems from that today. Nonetheless, Ms. Convery and I have thoroughly negotiated the resolution here. We both believe that it is the best outcome for a case like this, and we're asking the court to accept it. Forgive me, Judge. Just as it relates to sentencing, there are 4 matters that I would like to discuss with the court. These involve matters of the Department of Corrections and how Mr. Cannon will serve. He understands that the court has a limited capacity, well, really none, to give directions to Department of Corrections, but certainly
I can recommend anything I think is reasonable. It sounds like Mr. Hudson's explained to you, Mr. Cannon. There's a space on the sentencing sheet where I can recommend Department of Corrections, please do this, and do this. They can read it and say, sounds good, we'll do it. They can read it and say, that's not going to happen. But it certainly doesn't hurt to have the recommendation. I just need to make sure everyone understands that my authority over the case ends when you leave the county jail. I can't tell the Department of Corrections where to house you, what to make you eligible for or not eligible for, but I certainly can offer a recommendation. So you were going to say?
And along those lines, Your Honor, first, you would ask the court to have Mr. Cannon transported as quickly as possible. He would like to begin serving that sentence as quickly as he can. To the extent that it's possible, Judge, he knows that he's going into the state system. He also knows there are correctional facilities that are run by the state and private correctional facilities. He would ask to go to a private facility. Third, Judge, in Ms. Convery, she covered this, but just to make extra sure that he is allowed to go into a transitional center prior to his release. And additionally, Judge, and I'm sure the court will do this, but Mr. Cannon wants to be sure that he gets credit for every day that he's been in custody. By my calculation, as of yesterday at Rice Street, that was 1,197 days. Additionally, he was in juvenile custody for some period. Obviously, the jail would submit an affidavit of custody, as will BJJ. And just want to make sure that he gets credit for every one of those days towards the sentence.
Sure. We will make clear on the sentencing sheet that you should get credit at least from the day you got booked in at Rice Street. And that's a fact that my litigation manager can look up. That'll be an odyssey whenever it was that Mr. Cannon made it to Rice Street. If you're able to provide documentation, Mr. Hudson, as to how long Mr. Cannon was in the custody of DJJ, you can get that to Ms. Nelson.
Sure.
Or as you pointed out, what the sheriff does is that math anyway. I can't make a date up. You know, if I were to say he should get credit from the date of his birth, they would look and say, well, he wasn't in jail then. He was only in jail from this date forward. So they'll confirm the date that we give them, which will be the booking date for Rice Street. But if you can get that additional information, we can try to bake it in. But the record should be clear. Mr. Cannon is entitled to credit for all the time he's been in since he was taken into custody in this case. So is it from July 2, 2017? Maybe not. I don't know when he was arrested, but it'll be awfully close. You mentioned he was in the hospital for a while. The way Ms. Convery has described this case, it may have taken the detectives a while to figure out who did what and who ought to be charged with anything. But as soon as Mr. Cannon was taken into custody in connection with these charges, the clock started running.
That's right. I believe, Judge, at this time, Mr. Cannon wishes to address the court.
Okay, did you have anything else you wanted to say, Mr. Hudson?
Other than that, Judge, prior or directly after sentencing, before Mr. Cannon is taken into custody, if the court will allow, he would just like to speak briefly with his family here, particularly his mother.
I'll see what the deputies are willing to support on that. But Mr. Cannon, you have a right to share with me whatever it is you want to share. Your comments may be directed to other folks in the room. Make sure you're facing me and talking to me about it. Everyone is listening.
I said, I lost word, if you know what I'm saying. Your Honor,
Hey, I want to be clear. You don't have to say anything. Mr. Hudson said you did want to say something. I'm not making you talk if you don't want to.
I speak. I understand that I'm locked up for these charges, but I ain't guilty of it. And Your Honor, I didn't force nobody to get no call or do anything that they didn't have no willing state of doing. Because at the time, a 50-year-old can't tell the 30-year-old man to do what he want to do. So I'm sorry for Trevion or dying. I mean, I go through it every day. Think about him every day. So
How long had you known him?
like I say, 5 months. But
Who is the 30-year-old you're talking about?
I ain't talking about no 30-year-old. I'm just in general speaking.
Pointing out that you were the kid in the situation.
Right, exactly. So I just want to say that I'm sorry that they did lose a loved one, but none of this was never my plan intentionally. I didn't intentionally do nothing. I was just there. And I understand because the situation, the circumstance, this is what I got to do in order to get back out to go to my family. You know what I mean? So I do want to apologize just for them losing a loved one. You know what I mean? I didn't really have a whole thing to write down and say. I just wanted to say sorry.
Sorry is pretty important. You don't have to write that down. If you feel it and you're saying it, that's important to share. So you got hit a bunch of times as well.
Yes, sir.
How are you doing physically?
I still got a bullet in my back and in my leg, but what can I do?
And you're able to walk, but are you in pain all the time, or what's the situation?
I mean, sometimes it hurt, but I just deal with it, like the situation at hand.
Yep.
I just got to deal with it.
You do. All right, Mr. Cannon, I appreciate you sharing that. Mr. Hudson, I know there are family members of Mr. Cannon here. Did they want to share anything, or they're here and their presence is what they want to say? So you can be at the podium with whoever this is. Just let me know who it is who's coming up, and Mr. Cannon will go back to the table.
This will be Mr. Cannon's mother, Your Honor.
Good morning.
Brother, how are you?
I'm okay. Can you state your name and spell your last name for the record?
Shakia McMillan, McMillan.
Good morning, Ms. McMillan.
Good morning. I am the mother of Dwan Cannon. Dwan has been my special child all his life. He's taken the place of his dad. His dad died in a car accident, August 29, 2009. Dwan has been diagnosed with a mental illness that he's had all his life. Sometimes he has episodes of his mental status not cooperating with his personality. And on this particular day, I remember it very clear. He was having an episode. I never met Mr. Daniels. Unfortunately, I never got to meet him, but my son loved him to death. The whole time that he was in the hospital, shot those 17 times. Yes, 17 times. He has no spleen, half a pancreas. He was shot in his back. He has a bullet that's lying in his back. If it moves, he'll die. So the whole time he was needing to get treated for his wounds, he's looking for Mr. Daniels. I didn't meet him, so I didn't know him. And I'm thinking that, he's having an episode, something's wrong with him, But he's looking for Travion. And I'm wondering why I'm not knowing anything. But Mr. Cannon began to pray because he couldn't find him. And I didn't know what we were doing, who we were looking for, what was going on, I got a call, said my son was shot. I went to the hospital. One of Mr. Cannon's legs was over here. One of them was over here. His arm was displaced, everything. So I sat at the hospital 27 hours to get Mr. Cannon reconstructed back to his normal self. I do believe that the situation did not happen the way it was told. But we're neither here nor there because we're here.
We are here.
We are here, And to Mr. Williams' family, Daniel's family, they have been very supportive for their loved one. And, my son has asked for her several times, but he didn't understand. He didn't understand her situation, as far as she can't talk to you, He's steady asking for her, and I can't tell him, I just couldn't tell him, the severity of all of this because he's still not knowing what's going on. But this is a whole unfortunate situation that shouldn't have never happened because Mr. Cannon was supposed to be getting a ride. He was paying for a ride, but in the midst of something, they had something and then something went on. He had a baby. Mr. Cannon had a baby. On that, 2 days after that, Mr. Cannon had a baby, but he was trying to get to the baby's mother's house and he had paid for a ride and this in particular thing happened. I asked my son, who are these people? He said, I don't know. I only know one person, Ma. in the car. That's all he knew, is one person in the car. He knew nothing else, nothing. But what I want the court to take into consideration that this is a 14-year-old kid turning 15 at the time. So he didn't even know what was what, Your Honor, at the time. And his mental status is here with you, but it's not. And he doesn't want people to know that. But I'm here begging you for leniency on my son. He hasn't received any medical attention since he's been at Rice Street. They haven't given him any pills. They haven't done anything for him. I do thank you for your time, because we shouldn't be here talking to you right now today. But it has impacted the lives of his younger siblings and all of that. They're not allowed to go out. They can't have friends. But I do ask you to take into consideration my son. And I know that you are fair. I have watched you with other people in other trials. I have sat here quietly when you're not knowing, watching you process things. And I know that you're fair. And I thank you for your time, Your Honor.
Ms. McMillan, you're very welcome. This is a time for me to hear from everyone who cares about the folks who are involved in this matter. Tell me what you believe your son was diagnosed with.
He has ADHD, he's bipolar, and he has PTSD at this time. He takes Seroquel, Adderall.
You say he takes, but then you said he hasn't. He did.
No, he takes it with me.
Got it.
Yeah, not in the. Yes. He's been prescribed. Dr. Ahmad is his doctor. He goes to a behavioral health clinic, and that's how we do with Dewan. He takes 7 different medications. Well, he's supposed to take 7 different medications, but he hasn't taken them since he's been here at Rice Street here now.
Okay.
And his siblings, his older brother would like to speak to you. Well, his younger brother, I'm sorry, but he's the older big brother because he has the most,
How old is he now?
He's 15.
Okay.
All right. Thank you, Your Honor.
Thank you. Appreciate you being here. All right, Mr. Cannon, why don't you come back up? So, Mr. Cannon, have you understood the things we've been talking about today? I know the Alford plea, we spent a little extra time going over that, but do you feel like you've understood what Ms. Convery was talking to you about, what I've been saying, and what Mr. Hudson's been saying?
I ain't gonna lie to you, Your Honor. I understand, but I don't, though. I'm just going with the flow.
Okay, well, I appreciate the going with the flow. I guess a different way to put it is, do you have questions about the things that we've been talking about?
Just credit for the time, sir, part.
Mm-hmm. What's your question about that? Will you get it? You will get it. The only unknown to me is when you actually went into custody. Mr. Hudson correctly pointed out there was a window of time when you were at DJJ. I know when you got to Rice Street, but we'll figure out. Let me find out. Ms. Nelson, are you able to? She's checking. Look at that. Okay, Ms. Nelson is checking now. So we will get from Ms. Singleton the date you got sent to juvenile justice, and that'll be the start date for the credit that you get. It'll actually be written into the sentence that I sign. So I'm making it up, but if it was July 30th, 2017, that'll be the date. So you will have already done almost 4 years of the sentence.
The only like sort of caveat to that I just want to make sure everyone sees, he was released on bond at some point during the pendency of this case, and then booked back in. So if whoever just looks at the last jailing, it's not going to be his full.
Got it. How long were you out on bond, Mr. Cannon? Ballpark. I mean, was it a day, a month, a year?
Know how long I was in custody. I know how long I was out too.
How long were you out?
Like 2 months.
Okay. So that's not going to make a big dent. So you're going to get credit for all the time you've been in, minus, I guess, whatever that time you weren't in, if you were out on bond. Why did you go back in after you were on bond?
I had, it ain't hit me that I was locked up for murder. I was being charged for it. You know what I mean? I still want to do your own thing.
Okay. And whatever you were doing as your own thing got you arrested again?
Yes, sir.
Okay. Well, that would explain it. All right. Well, Mr. Cannon, I find there's a factual basis for your plea. If this were a matter that went to trial, the jury would be able to find, I'm not saying it would, juries do mysterious things, but if the jurors heard testimony from Mr. Blow and Mr. Parson and Mr. Griffin and Mr. Williams that aligned with what Ms. Convery said, a jury could find you guilty of, in particular, the armed robbery, which is, according to the state's version of facts, how everything started. No one is accusing you of having been the one who fired the shot that killed Mr. Daniel. It's not how the law works here. We have situations where two guys go into a bank, security guard shoots and kills one of the two bank robbers. That other bank robber gets indicted for felony murder because the two of them were going in to do something they shouldn't. And as a result of that, the guy's co-defendant gets killed. The defendant never pulled the trigger, would never shoot his buddy, but their decision to do what they did justified what the security guard did. And lo and behold, the guy who just meant to go into a bank to get some money is looking at murder charges. That's not exactly your situation, but it's pretty darn close. So I'm not finding that you pulled the trigger, that fired the shot that killed Mr. Daniel. Clearly, Mr. Daniel is dead. We can't get him back. And a jury could find from the testimony of those other individuals that what started the process that resulted in Mr. Daniel getting shot, you getting shot some large number of times, was something you were responsible for. I also find that your plea is knowing and voluntary. A voluntary plea is one where a defendant says, this is the way I need to move forward. No one's forcing you to enter the guilty plea. You may not be excited about it, but you've decided the way to move forward for DeJuan Cannon is to enter this plea. Is that a fair description of where you are?
Yes, sir.
A knowing plea just means that you've understood what we're talking about. And again, understand doesn't mean you accept the circumstances in which you find yourself, but it means when someone says your sentence is going to be this, or you're giving up that right, you understood those words. You know that by entering a plea, you're not going to have a jury trial. Mr. Hudson's not going to call witnesses on your behalf, et cetera. You feel like you understood those things?
Yes, sir.
Okay. Then I'm going to accept your plea. I'm going to follow the recommendation. The state could have taken this to trial, and if it didn't go well for you, the only sentence I could give you is a life sentence. If you were found guilty of felony murder at the end of the trial, your sentence would be life plus the 5 for the gun. But because of the state looking hard at these facts, considering your age, considering the thing you and I have just discussed, which is, doesn't sound like you shot Mr. Daniel, but he's dead. An appropriate sentence is something far less than life. And that's why I'm sentencing you pursuant to 1710 6.1E. That's a lot of numbers in one letter. It basically is a way that if the state agrees to it, I can go below that term of life. I think it's appropriate in your situation based on what I've heard, based on what Ms. McMillan has shared with me about your situation. I think that what the two sides have negotiated is a fair reflection of how serious this is, but also of some of the mitigating circumstances. So where I come down is that it is appropriate to sentence you to the 18 years to serve, credit for almost 4 years. And again, we'll get those dates. So you can do the math as to what's remaining. And I am going to have the balance be on probation, not just 2 years, but the full 7, to make sure that when you are plugging back in with your family and getting back to life on the outside, there is a slightly longer window when you'll benefit from supervision of probation. I'll have as a special condition of your probation, no contact with Mr. Griffin or Mr. Williams. Those are the co-defendants. And that while you're on probation, you don't affiliate yourself in any way with any gangs. You wouldn't post things online suggesting you're part of one group or another. Obviously, you wouldn't spend time with anyone who is openly and notoriously a member of any gang. I will recommend that you be allowed to move to a transitional center as soon as the Department of Corrections believes that that is appropriate. I'm not going to pronounce the specific sentence per count because I need to figure out the situation with vacating and what survives. I'm inclined to follow Mr. Hudson's. Well, I guess what I can do is I can pronounce the sentences to each count. I got to figure out what merges and what's vacated. But I'm inclined to follow Mr. Hudson's recommendation about having count 5 be the felony murder count that goes forward and the others are vacated. But as we stand, the sentence for Mr. Cannon on counts 1 through 9 would be 20 years to serve 18 with the balance on probation. There'll be some merger and there'll be some vacatur, meaning things will be vacated of those counts. They'll all run concurrently with each other. Count 10 will be 10 years to serve, and count 11 has to be consecutive. It has to be 5 years, but I'm probating that. Count 10 will run concurrently with the other counts. So overall, that is a 25 to serve 18 sentence with a balance on probation. And again, Mr. Cannon should get credit for all the time he has served in connection with these charges. Ms. Convery, anything else in Mr. Cannon's situation?
No, Your Honor, nothing else on behalf of the state. And for what it's worth, I agree with the caveat that I don't have a case either, but I agree with the court's analysis that the murders will vacate, but the predicate should still exist on the sentence.
Okay. And Mr. Cannon, if that's a piece you're not understanding, that's okay, because I'm not understanding it. What you should hear is it's not going to affect your sentence because I'm running all these things at the same time. So the numbers don't change. This is a legal issue so that we don't get the sentence kicked back by the Department of Corrections and then we're stuck. Mr. Hudson, anything else?
There you are.
Thank you for your time. Sir, Mr. Cannon through counsel has asked if he can have a non-contact 30-second, I'm going away for the next few years. I always defer to the deputies in the courtroom. If that's something that's okay, great. If it's not, I'll enforce it. So you tell me.
2 minutes, Judge, that's it.
Okay.
2 minutes.
We'll make it happen.
2 minutes.
2 minutes. So Mr. Cannon, you stay standing, you turn around, you can face the family. I'm going to ask Mr. Daniels' family, Ms. Thurman Butler and others to step on out. And once you've stepped out, I'll leave too. You all can talk. You all stay seated, please.
Stay seated. Stay where you are.
Thank you.
Thank you, Your Honor.
Thank you, Mr. Hudson. And thank you, deputies. Appreciate it.
Thank you, Ron.